Welcome to Leadership Team Talk. David, delighted to have you join us today.
Thanks for having me, James. Lovely to be here.
Just to introduce David Rushmore is a partner at Machin's Solicitors, and you run the employment department. That's right.
That's right. Yep.
And we are effectively 100 days on from the Labour's pledge, and that's exactly why I've invited an expert to speak about it today. Because we're getting questions. I know you're getting questions when we spoke over. Is like, are new laws in place yet? You're getting questions like that firing in from people. So this session is really all about giving people an update on what we know at this point on that 100-day pledge around employment laws. So maybe let's just start off, David. What has happened exactly? Where are we in the process so far? Because I think it was quite an ambitious challenge, wasn't it?
Certainly an ambitious challenge. One that I have to say I was slightly surprised that they'd committed themselves to. But I mean, again, unless you've been living under a rock, well, I suppose unless you're living under a rock or have no interest in employment generally, you probably quite cleverly what they've done is introduce the Employment Rights Bill, which is the sort of skeleton of the changes, and the flesh will be coming on a bit later with some further laws that they'll introduce in the future, largely through more detailed consultation. So the big seismic changes, we've got a good idea of what those are. Those are in the bill. Some of the fine detail we think is going to come a bit later. And obviously this gives Labour this chance to meet their pledge. You know, no one can say they didn't introduce legislation within 100 days because they did. It's just when we will actually see the effect of it.
Right.
Probably a good 18 months to 2 years. You know, the bill has to get all the way through Parliament. It's still at a pretty early stage. Now, the reality is, you know, Labour have such a huge majority that it's not going to be disrupted in its passage by, you know, Tory rebels some Labour rebels and some Tories kind of clubbing together and saying, let's get rid of this. That's not going to happen. We have to assume most likely the bill's going to come through largely in the state it's currently in.
Right. Okay.
But there is a very substantial piece of the process left where the bill is read in detail, is considered, amendments are proposed, and we go through that process. So there is going to be some changes. I don't expect they're going to be that substantial. And in fact, if anything, they're probably going to be quite practical because they'll be changes made through consultation. So right now we're engaging, or Labour are engaging in consultation. They're looking at a number. So just the other day, they announced 4 separate consultations on 4 different rights that are coming out of the Employment Rights Bill. And the idea would be to engage with key stakeholders, so business owners, you know, employee rights groups, anybody really who wants to get involved, to put forward an opinion to try and say, is this going to work? And is there something we need to change? That could bring about some amendments, which may turn up in the sort of more final text that then goes to the vote. And obviously, hopefully, is the version that's most likely passed as the becoming probably the Employment Rights Act 2025. I would hope it's probably completed its passage next year. I don't think it's going to run into 2026. But obviously, then you still have this, even when it becomes law, what tends to happen is the law doesn't necessarily bite straight away.
Right.
You tend to get staging dates or dates when the law is actually introduced. So there will be plenty of lead-in time for everyone to understand exactly what the law is going to be and when it's going to start. It's not like we're going to suddenly see, on Monday, everyone needs to change the way they do everything. And coming to what you said earlier, I have, funnily enough, already had some calls from clients saying, so this new law, is it in place yet? You know, what do I have to do? And
so what advice are you giving them, David, at this point in time?
It's a great question. I mean, the reality is nothing. You know, you don't have to do anything right now. The law is still the law as it stands. There is no real reason to change the way you're doing anything until we see this, until the Employment Rights Act comes in. So particularly things like unfair dismissal. You know, there's a lot of talk in the press about it becoming a day one right. The reality is keep your recruitment practices as they are, keep your practices as they are. because the law isn't going to change for quite some time when it comes to that. But it just shows how interesting it can be with obviously the press pick up a story, the story gets out there, people don't quite follow exactly what's going on, the nuances of legislation is not something everyone's that familiar with. So a lot of people just see it as the law's changed because that's what the press is telling me.
Yeah.
So, but it is going to be, though, probably the most significant piece of employment rights legislation, I would say, since 2010, when we had the Equality Act come in, and that consolidated, all the various acts on discrimination. The Employment Rights Act 2025 is going to be the most substantial change to our employment rights in this country for 15 years. So certainly something to again, if you employ people, it's worth keeping your ear to the ground in terms of what's going to change, because it will have an impact on how you run your business.
But right now, what I think you're saying is, look, wait for the actual confirmation of the changes rather than take action now.
Yeah, you can obviously start doing some preliminary work if some of the key changes are going to impact the way you operate your business. So, for example, if you're very heavy on 0 hours contracts, there are going to be some changes to the way 0 hours contracts work.
Okay.
You might need to review your business and see, is that model sustainable? Is that something that you're going to be able to work with? I would say none of the changes are going to be that dramatic that it should really disrupt anyone's business model. It just might increase the cost slightly of hiring people, of retaining people and employing people. So again, that might factor in. But no, I don't see anything which would say, right, this group of people or this group of businesses need to change completely the way they work, because it's not going to be lawful in a year's time to be able to work like this. So.
Absolutely. Okay, shall we? You mentioned 0 hours contracts there, and this isn't a thorough update on the whole thing, but for those people who are less familiar, perhaps we'll just do a quick run through of some of the key, not changes that are going to happen, because we don't know that yet, but the things that are in the bill up for discussion. So 0 hours contracts. Let's just start with that. What is the kind of number one or major change happening, or could happen there?
Yeah, I think we can generally say these are, we're pretty 90% sure that the changes that they have in the bill are probably going to be the changes that come in.
Right, okay.
As I said, I can't see anything realistically derailing the Act such that it's scrapped or changed completely. It's probably changes are going to be fairly minor. So I think we can be quite confident on these. But yeah, the big change at the moment, 0 hours contracts have been under attack for a while. Even under the Tories, they were slightly under attack in terms of exclusivity clauses. So it barred you from having staff members who worked on 0 hours contracts, which, again, for those who aren't familiar with them, are contracts where you effectively have somebody who works for you, where you don't have to give them any work at all.
Yeah.
And then you just tell them when there's a shift, and if they want to do it, they can do it. So, lots of industries, particularly things like hospitality, they rely on 0 hours contracts. And equally, a lot of employees, a lot of workers rely on 0 hours contracts. Those with slightly less atypical lifestyles, they need 0 hours contracts. Sometimes you might be holding down 2 or 3 jobs. It might be a great way to have a second job. You could pick up.
Yeah, so there are actually advantages for employees, exactly. Aren't they?
And so they are something which they have a very much a place in our business landscape for people to fill 0 hours contracts. What's going to change is, in some ways, to give a bit more certainty to the employee. So there's going to be a shift towards some guaranteed hours. So largely you're going to end up with a reference period. So there'll be a sort of 12-week period or a 9-week period. Again, that's where we might see some change in terms of the final wording. But employers will be required to look across a reference period and say, okay, this 0 hours worker generally is working 6 hours a week. And so it will largely move it towards this sort of guaranteed hours every week. So there will be a certain amount of flexibility lost.
Right, okay.
In that you if your business model relies on having lots of people on 0 hours contracts where almost you sort of throw out some work and see which are the first three to put their hands up and then bring them in. That's probably going to be a bit harder to maintain as a model, because people are going to be able to start saying, hang on a minute, I'm entitled to my regular hours. And it doesn't matter who necessarily puts their hands up first, I should be getting those hours. So there will be some change in the flexibility of a 0 hours contract, but having these very flexible contracts, they're not under attack. So they're not going to disappear. They're just going to be slightly
So
less.
I guess as an employee, because these things are going out into the public domain, and i.e. the the average man with that contract or woman is going to see press about them, then actually, if it impacts you, even if it's not law yet, you've got the opportunity to be proactive if you want to, haven't you? In that
Yeah,
context.
I think in terms of a practical step for employers, as I said, I mean, this is to some extent true of most of the changes. Obviously, being a Labour government, it's a shift in the power slightly towards the employee away from the employer. So if you're an employer of a lot of people on 0 hours contracts, you might want to look at consolidating in terms of, who are your regular workers, who are the people you normally rely on, who are the ones that are slightly more flaky, and maybe starting to put those ones who are your better workers onto already guaranteed hours contracts. So get them onto a minimum hours contract, so 12 hours a month or 12 hours a week, whatever works, so that you can lock those people in.
Yeah, particularly in today's Labour, economy.
Exactly. So exactly. So rather than, as I said, having a sort of wide workforce where you just take whoever's available, focus in on the good ones and ensure that you've secured them as your staff going forward, so that when the changes do come in, you're not risking losing those people because of just how the shift patterns happen to fall at the time the law comes in. So I mean, it's not, again, a substantial change in that we're not going to disappear. We're not going to see 0 hours contracts disappear, but that shift of power towards the employee a bit might make employers think, okay, let's rebalance it voluntarily, rather than waiting until the power shifts sort of involuntarily.
The next one, I believe, is flexible working, which always mystifies me slightly, because it's just your ability to ask. Is any
That's right. I
what's
mean,
changing there?
there is going to be quite a substantial change with this, because where we are at the moment is flexible working is a right to request, exactly as you said,
Yeah.
not a requirement that the employer gives you flexible working. So at the moment, employers can largely refuse it where they can find a good reason not to. It's going to shift a lot more burden onto the employer to effectively justify a rejection. So it is going to move closer to a right to flexible working rather than a right to request flexible working. So,
Okay.
I mean, that is going to have quite a substantial change for employers. Obviously, that employees will be coming in and suddenly asking for changes of hours, changes of work location, etc. Again, if you want to start embracing this change probably earlier, maybe start reviewing your flexible working policy, looking at how people can work remotely, how people can do more flexible hours, because it may be that those who want the 9 to 5 in the office find that a little bit harder to maintain once this right is in place.
Can we expect like a sort of a list of rules or guidelines or something?
Yeah, I mean,
this
is the sort of flesh that we're looking to the bones. The bones are, there's going to be this, again, shift in power towards employees to have more of a right to have flexible working rather than a right to request. It's clearly going to need a lot more detail around exactly how that's going to work, so that it's clear on where can they be refused, what's left for the employer to say, unfortunately, I just can't accommodate that, and how that's actually going to work in practice, and obviously also how it's going to be enforced, because we need to look at taking for example a tribunal claim where you're saying, well, they refused my flexible working request. Generally, employment tribunals haven't stepped into the shoes of employers and sort of made decisions for them and said, oh, I can see how you could make this work, so make it work. Usually it's been more along the decision-making process of the employer and making sure that that's rational. So again, I think there will be this shift of power towards employees. I think we'll need to see that one follow its full passage through before we're exactly clear on how employers are going to have to accommodate flexible working requests.
And flexible is quite broad, isn't it? A lot of the time, people think of it as kind of work at home versus a location, but it's far broader than that, isn't it?
Yeah, I mean, generally it's the hours that you work, the days you work, or the location that you work. It's that level of flexibility, or those elements of flexibility. But obviously, then it's a combination of both. So you might be asking to work on different days, work at different hours, and work in different locations at different times.
Okay, so if I'm running a restaurant, obviously my employees need to be at the restaurant.
That's
That
right.
would be more about the shifts that they do. Would be the flexibility
Exactly.
there.
Yeah, exactly. So it's still got to maintain that reality of you can't have flexibility the same in every employer. If it's a desk-based role, which is largely working with clients online, there's a lot more flexibility there than there is, as you said, in a restaurant where you've got to come in and serve the customer. You can't work remotely and serve customers.
It's quite
Not
an interesting area because a lot of people have embraced hybrid working as a new norm.
yeah,
Some employers have kind of completely gone the other way and say, right, COVID's over. You have all got to come back to the office now. I don't care if you don't want to. It's not my approach. Will they have less choice to just
yeah. I mean,
dictate that?
those sort of blanket in the office policy, that's probably going to be much harder to maintain once the law changes. It's going to fall a lot more to the employer to justify why remote working isn't allowed. So, as I said before, there was a lot of freedom on employers to say, well, I've looked at this, I've considered it, I don't think it's going to work. The bar is going to be a bit higher now. So you're going to have to work to show that it can't be done working from home.
Yeah,
Um,
that's quite interesting because whilst nothing's law yet, and it might not be for 18 months or so, if people are in the midst of changing career, that's not necessarily a short term decision for them. So they might already be considering these things.
yeah, I mean, I think the people obviously the businesses that really need to think about it are the ones who have these blanket in the office policies and take a view generally of rejecting flexible working requests. It may be worth starting to review your flexible working policy and actually seeing where you can be flexible. You might find that you could sort of head off slightly more onerous flexible working requests by introducing a middle ground now. So rather than maintaining a 5-day, let's take a 5-day 9 to 5 in the
Yeah.
office policy, if you start flexing a bit on that now and saying, all right, let's do 3 days in the office, 2 days working from home, you might find that the staff are quite happy with that. And actually, when these rights change and their rights in terms of flexible working become stronger, they're not making flexible working requests because they're already quite happy with
Good idea.
this.
Yeah,
Yeah.
great opportunity. Sick pay? Is there any major changes happening
Yeah, I
there?
mean, some of these ones are, they're not going to have a huge impact. Some of this is just about removing, sick pay sick pay is dreadful, to be honest, in terms of the amount that you can actually be paid. It's very low. There are days when you don't even get paid it for the start of periods of absence. So for some employers who obviously don't pay any sick pay at all, if you've got an employee who takes a few days off through the year, they could easily be losing out on days pay each time. This is just some tweaks in terms of effectively you'll be paid sick pay sooner. Interestingly, although we might have to see what the budget does, I don't think this will change anything, but the rate of sick pay hasn't been changed by this. So
Right.
you're still on the fairly poor rate of sick pay. You just can be paid that poor rate a little bit sooner. But obviously, again, sick pay, coming at it from the employer's point of view, sick pay is a huge cost to business. So this is going to be an additional burden placed on employers to pay sick pay to those members of staff again who have fairly sporadic absence, 1-2 days here or there throughout the year. Suddenly they're going to become entitled to sick pay, and that's
Do you have any idea if that's? Oh, I don't know if you'll be able to answer this, David, but if that's a big impact, i.e., are there a lot of companies that are on the statutory sick pay rather than having other
Yeah, I mean,
better
certainly
arrangements?
SMEs are quite frequently on statutory sick pay only. Offering company sick pay where you're entitled to be paid, full pay for a certain number of days absence in a year, generally that's a right associated with bigger employers because they have the means to
They
pay
can afford it. Yeah.
for those days when people can't turn up and work. A lot of small businesses, they simply just don't have the money to pay someone for a day that they don't come in and work, which obviously feels very unfair to the employee because they always say, I can't help it if I'm sick. But at the same time, the employer says, well, I can't afford to pay you and I haven't got enough money to do that. So it is going to have an impact, quite a significant impact on smaller businesses who probably will see their sick pay amounts go up quite a bit. So I think, it's a difficult, again, it's striking that balance of who's going to be hit by this. And I think, unfortunately, Labour are making it quite clear, all the talk for the budget is that national insurance will be going up as well. Again, that hurts employers. So a lot of this cost is largely going to be pushed on to employers, as fairly expected, really, from a Labour government that's where it would go, though.
Yeah. Okay. Well, we won't cover the budget. I know that's next week.
Certainly something I probably shouldn't claim to be offering advice on. I'm sure most of my
let's move to family leave. Is that changing?
Well, again, this one, a little bit more like sick pay again. So you're going to be removing qualifying periods. So people are going to be entitled to family leave sooner. Obviously, then also potentially family leave pay sooner. So it's just another cost that's going to fall onto employers, much like the sick pay cost. So not an awful lot to say, unfortunately, other than to probably build into your budgets a higher employee cost going forward because of periods of family leave being available sooner.
Yeah, okay. Well, there's quite a lot of costs adding up here, particularly if you're a small business.
I saw a figure the other day. I think it's something astronomical. Because the government have to issue a cost estimate. I think it was around 7 billion. I think it was of being cost passed on to employers as a result of the changes. Now, I have no idea how they come to that figure. Obviously, it includes everything, everything that's possible connected to the change of rights. But again, as we would always expect, anything that improves or strengthens employee rights typically comes at a cost to business. Now, you get into much deeper questions there about how you feel about that, but also generally unscrupulous employers take advantage of weaker rights. So let's take minimum wage, for example. If you're a good employer and you pay minimum wage, you could be undercut by someone who just ignores that and takes advantage of the fact that employees don't enforce their rights in that respect. So in some ways, strengthening rights is better for business generally because good employers are not undercut by unscrupulous employers. So it depends how you look at it. So you can't just directly say all of that cost is a bad thing for employers because some of that cost is going to fall to employers who wouldn't have paid it, would have undercut people by not paying it anyway. So
I'll share my own opinion rather than ask your advice. But in the SME world, that accounts for a huge chunk of the economy, and I think somewhere about a third of the employees across the piece. So I hope they are not stifling it by passing too many costs on to those SMEs.
That's sort of the fundamental discussion around this. Interestingly, in terms of commentary on the act or the bill, it isn't universally negative or universally positive. And it suggests in a way that actually Labour have struck quite a good balance in terms of strengthening rights, but not in such an onerous way that nobody can agree that it's the right thing to do. Obviously, it was always going to come at a greater cost. But to some extent, if they feel that it strengthens rights, gives employees more certainty in their roles, and allows them then to feel more certain, a more secure employee feels more able to go out into the market and buy goods and services with their free cash. So you've got this big circle going round of
absolutely.
It's a very difficult assessment on strengthening employment rights, passing costs on to employers, and then saying is that a good or a bad thing? Because they might also benefit from employees with a lot more cash in their pockets, feeling they can go out for dinner and visit their local businesses because they feel secure in their jobs, that they're not going to lose their job tomorrow. So.
Possibly, yeah. I guess on the flip side, it might force some SMEs to get really focused on productivity.
Well, and
move from 3 people down to
exactly
2. Use a bit of AI, and actually you've taken 2 people out of the economy and need to find another job.
That's the big balance.
There is a balance, isn't there?
Exactly, that's the big balance, and I think that's the one which we may well see, certainly on the unfair dismissal changes, in terms of what the outcome might be there.
So that's quite significant, isn't it? Let's dive into that. What's happening?
Exactly.
There, David?
The changes to unfair dismissal, probably the ones grabbing the most headlines at the moment. Again, for those who employ people, they're probably very familiar with what is now a 2-year qualifying period. It was 1 year. Certainly when I started practicing, it was 1 year. The argument was that employers needed a period of time to assess somebody, to decide if they were the right person for the job, whether they could do the job well, and whether they wanted
your probationary review kind of period.
Exactly. So that's what generally happened in that first period. So we'd largely got up to a point where effectively employees were on a 2-year probation period. Within those first 2 years, they had no unfair dismissal rights. Employers could just dismiss them, no real process. If they weren't happy with them, have them out the door. The big change, seismic change to some extent, is to make it a day one right. So employees will start and they will immediately have this right to unfair dismissal. In a way, it's quite clever what Labour have done, because they could have changed the qualification period just simply by passing a law very quickly, or a freestanding law, just changing that qualifying period down to, say, 3 months or 6 months.
Right.
They didn't do it that way. They've done it this way, largely to make it harder to undo in the future. So when they're no longer in power, when we flip back to whoever is going to be the next party, Labour's changes will make it much harder for that new government to reintroduce a sort of 1 year or 2 year waiting period for this right.
Okay.
So I think Labour is seeing this as a chance to really, again, bring about a sort of seismic change to this right. But they have helpfully recognised, they've listened to business in terms of saying, well, hang on a minute, we can't just hire somebody and then trust that they're going to be good enough to do the job from day one. What about all the ones who are embellishing their CVs, or claiming that they've been doing something for years when in fact they've really only been on the fringe? So
yes,
other than having really intensive recruitment processes, what are we supposed to do to check that people can actually do the job? So probation periods will still be there, and that's what's very clear. What we're sort of moving from is a kind of contractual probation period, where usually what you would have in an employment contract is your probation will be 3 months, 6 months, 9 months, whatever the employer wanted to impose.
Yep.
Generally with a right to extend it if they wanted to. Everything very much at the discretion of the employer.
So, I guess you felt like you had your 3-month test, but in the eyes of the law, the company could do what they like.
Exactly.
Yeah?
They could just do what they like, really, up to 2 years. What we will be moving towards is more like a sort of statutory probation period. So the period is yet to be fixed. We're expecting it to be probably 9 months.
Okay.
During which the unfair dismissal right will be relaxed. So that's how we're expecting it to be. In reality, it's probably no different to what I advise clients at the moment. So we have at the moment a day one unfair dismissal right in terms of what's called automatic unfair dismissal. So that's a right that protects employees against certain sort of fundamentally wrong dismissals, I suppose. So probably the most well known is whistleblowing.
Yeah.
So someone comes into your business, identifies an unlawful practice, tells the employer about it, and the employer decides that the better way to deal with the problem is to get rid of the whistleblower, not to deal with the problem. That's been unlawful for a long time, and you don't have to have 2 years service for that. You can have that from day one. So we've always had these dismissals that would be unlawful. It's just going to broaden it out now really to everything. Now, best advice or best practice for employers even dismissing someone with under 2 years service is not to go, oh, well, you don't have your rights, so therefore I don't have to tell you anything or do anything. Because you can still be challenged on the basis of these day one dismissal rights. Is ideally you still go through something of a process. You might not be as thorough, but you should still go through some process. So again, if you've got complaints about an employee's performance, in some ways sit down, tell the employee the complaint, listen to what they've got to say, and then dismiss them for it. Don't just say to them, I don't really need to tell you anything, so you're fired. Because an employee who doesn't understand the reason is more inclined to go to a tribunal to challenge it.
Yeah.
So good practice was always take them through something of a process, give them an explanation, because they're more likely to accept it. The way the statutory probation period will work really puts that into law rather than good practice. So employers now will need to still sit down with an employee, talk to them about their performance, talk to them about their conduct, whatever their reasons might be, and go through a sort of truncated process.
So there's a formal process that you'll
exactly. So it's just a bit more formalised than again, some employers would take the view, well, I don't have to, so call them into a room, tell them they're fired, put their stuff in a box and send them on their way. And don't even tell them why, they're just not happy. This is going to make it a lot more, okay, you're going to probably need to have specific examples. You're going to need to hear what the employee's got to say on it. You're going to need to listen to what they say and then make a decision. So there will be this formal process around probation and dismissals for probation.
Is there any indication of when that might come in? I know you can't commit to this.
So this is the one we're expecting sort of 18 months to 2 years, most likely. So we'll get the whole passage of the Act. It's going to come through, and then we've got to get this statutory process around probation periods before realistically the right can work.
Yeah.
In terms of businesses right now, there's not an awful lot you can do with it, because you can obviously, if you wanted to clean house, I suppose you could get rid of your staff with under 2 years service now to make sure that you don't have anyone suddenly gaining a right in the future. I wouldn't do that straight away. I would wait to see where we get to.
It's interesting though, because look, with all of the other costs we've talked about, some employees, rightly or wrong, how it impacts the individuals, I've got total empathy. But some employees might think, well, I need to clean my house, to use your word.
Yeah, absolutely. And I think in practical terms, I would say it might change your mindset slightly. So where previously you might have thought, we need another pair of hands, let's just get someone in, give them a job, get them doing the job, and then we'll get rid of them in 6 months if we don't need them anymore. I wouldn't be quite so quick to hire once this comes in. You need to be a bit more confident that role is going to exist long term. I think the other is review your recruitment processes. So, it always astounds me, I think, when I meet clients who literally have one interview and that's it. You just meet someone once for 20 minutes and you offer them a job on the back of that one interview. Try and start developing slightly more robust recruitment processes. So perhaps you want to introduce some sort of assessment, bring in some technical questions if it's that sort of role. Ask the employee to explain themselves so you can have some confidence that they actually do know what they're talking about on the role.
Yeah, I know. I'm a massive advocate for things that actually get the individual to demonstrate their abilities, particularly as you've got a front end now, which can be kind of AI influenced, whether the candidate is using it or whether you're using it as part of the recruitment selection process.
Yeah, you've got some data issues sometimes with AI, but certainly engaging more with candidates and trying to make sure that they are the right person. So in some ways, shift some of your probation period to before the employment even starts. Have a look at them in a bit more detail, go through a bit of a more thorough hiring process so you can be more confident that when they start, they are the right person for the job, rather again than just, we need a pair of hands, 5 interviews, 20 minutes with each one, pick the best person, then put them on the tools.
Which is a good thing, ultimately, because it costs an awful lot to get someone into your business, train them up. Maybe it takes, depending on the job, between a month to 12 months for them to be really effective and paying their way. So there's lots of positives there.
Yeah, I think so. I mean, I think, again, it's very easy to sort of view a lot of these rights changes as just being further cost to business. But actually, again, if you look at this from the point of view of a lot of employers would have been doing that already. Now, that's quite an expensive process to really invest in your recruitment. It takes some cost. Your competitors might see it as, you know what, I don't need to worry about that because I can just get them in, get them working, and fire them in 6 months if I don't like them. So you can be undercut by those competitors
Right.
who don't really need to invest in their recruitment processes. Arguably, this makes it more sensible to do that, and so the cost of just hiring people in and then disposing of them is going to fall to those competitors. So actually, hopefully, if you've got good, robust recruitment processes, you might feel now you're on a bit more of a level playing field with your competitors, who probably, if they're going to cut corners in recruitment, are more likely to pay the cost in a tribunal down the line when they try and get rid of people who aren't good enough for the job. So it could
Absolutely. I
just
mean, so a lot of things in the employers and the employees' favour. I mean, it could. I mean, hopefully that positively results in people investing and training and developing their people better. Because if you've gone through all of that and it's harder to get rid of them, you're going to want to develop them.
yeah. I mean, it's a really interesting point, and I was reading an article actually just this morning of a barrister who's making that sort of point of actually this is a paradigm shift in terms of the reasoning behind strengthening the rights. It changes a lot of employment rights, or it shifts a lot of employment rights away from almost pure capitalism to something bigger than that. That
Yeah.
and the one of the other rights, which is the fire and rehire one, which is shifting, which a lot of people will probably remember of the P&O matter that happened a few years ago,
Yeah.
where largely someone had sat down with the numbers and said, what's the cost in terms of just the actual number of getting rid of all these people? How much do we save by getting rid of them and replacing them with cheaper labour? And it becomes a mathematical equation.
Yeah.
And at no point does anyone think, hang on a minute, these are people's lives, this is real
Yeah.
people. The strengthening of the rights largely looks to make it a bit more about these are real people with lives who need to plan their lives around an income. And so tries to make some of their employment rights less about, can I just give you some money to buy it out? And actually, I've got to deal with the more sort of substantive problem.
Yeah. The
So,
person.
so
Yeah.
again, like the flexible working one, you look at that as you can't just really get rid of inflexible people by saying, oh, well, I want you in the office anymore. It's going to make it harder to do that, strengthens their position, hopefully makes more people able to engage in that sort of flexible working, protects more of them, and changes the way we work to a more flexible working style. Because it's not a race to the bottom in terms of those who are willing to come into the office or who can come into the office keep their jobs, and the ones who want to work from home for, say, childcare reasons lose their jobs, and you end up maintaining that practice. So a lot of these rights are, I think, going to change to some extent. That if you're an employer that views employees simply as a resource, as a cost, or as a balance between how much you pay them and then how much money you can make out of them, that is what's probably going to change slightly under this. With this.
Yeah. Which is again, it's a good balance because people are
And
people are people are wanting companies that beyond money, investing in
that's
investing in
right.
them and their development is the number two thing that people want from an
That's right.
employer.
And I think, and again, it's interesting that society is moving, or our society is moving that way. And perhaps Labour is sort of having its day in terms of that's a very hot topic for people now, and strengthening unions and things like that, and bringing employees together, shifting the balance of power away from the business owner towards the unionised workforce or the workforce as a whole. It aligns with a lot of what people are asking for anyway, in terms of changing
It's
the
interesting
work.
because I've worked with some great people, and some people they put a lot into developing their people. If they decide they leave, they will welcome them for the right reasons. They'll perhaps invite them back into the business when they realise the grass wasn't greener.
Yeah,
Not everyone's like that, of course. So I'm just thinking of some of the knock on effects. I don't know. As an employer, maybe I'm thinking, well, maybe do I want to extend notice periods? Well, I'll be able to. Again, you might not be able to give a definite answer, David, but other employers are going to adapt what they can around these laws, that could be. Will those things be
Yeah, I
allowed,
mean,
or
again, I mean, taking that one, I mean, there'd be no reason why you couldn't extend notice periods on the back of this. I mean, it'll be interesting to see. I mean, obviously, as with every law change, there will be those sort of cutting edge types who see an advantage or an opportunity in
yeah,
the change of the law. So, yeah, I mean, I don't see why we wouldn't see consequential changes in the way that contracts are written, that employees work, because of the changes that come in. I mean,
yeah,
as I say, coming back to that point, it's a seismic change of employment rights, and so we're going to see probably a lot of disruption around how people work.
absolutely, yeah. There's a lot of change. I won't ask you to speculate, David, because there's a lot that can happen. Is there anything that we've missed that's important?
No, I mean, I think that touches on most of the key ones. Obviously, we haven't touched on everything at all. It's far bigger than that. I think there's so many minor changes and other changes that are going to come in. As I said, we haven't even touched on the union side of things. There's a whole raft of measures in there around unions, access to workforce, and things like that. One interesting one I think that we'll just touch on just at the end is about enforcement,
Right.
which again is another really interesting element of employment rights. When you think about, actually, it doesn't matter too much what employment rights are. If people can't afford to enforce them, they might as well not exist. And the employment tribunals at the moment are hugely underfunded, are really struggling. I've seen in the last 5-10 years that the time it takes to bring a claim to the tribunal becoming longer and longer. And for most people, they just don't want to do it.
Right.
And now that unfortunately means that then they don't bring a claim, which means, again, unscrupulous employers can get away with unscrupulous practices because they know they're probably not going to be sued by the employee. One of the changes is bringing in a slightly stronger enforcement body. So bringing together a number of other enforcement bodies, which will sort of take up the fight on behalf of certain employees. One of the really important ones is around pay.
Yeah.
Shortfalls in pay are very poor claims generally, because the principle of employment tribunals is you don't get your costs paid by the other side. So if you go to see a solicitor, if you've been, say your employer's held back some money saying, I'm not going to pay you these allowances this month, or,
Yeah.
and you've got £1,000 of deductions from your salary, you go to speak to a solicitor about whether you could recover it. You might have paid £1,000 to get legal advice to find out that they shouldn't have taken the money away from you, but you don't get that paid back again. So you go to find out whether you should be paid. You find out you should be paid, and the money you find out you should be paid pays off the bill to the solicitor to tell you how much you should have been paid. So it's pointless.
Yeah. Or
So a
worst
lot of
case, you've
pay
lost 2 grand.
claims. That's right. So a lot of pay claims, really, you want an enforcement body that can help you go after the employer and make sure that employees are paid properly. And again, that one is of benefit to very legitimate employers. Those who pay properly don't need to worry about this.
Yeah.
But what they do worry about is their competitors who don't pay properly. And so an enforcement body coming in to make sure that rights are enforced, again, it makes employment rights of value to the employees, which means that unscrupulous employees have to worry about them.
It sounds fairly fundamental for this to work. Otherwise, you're probably just extending the void between those people who are doing everything better than the law suggests, and
That's
those
right.
people who are just living on the edge.
Exactly. I mean, that's what if you're a good employer that takes the law seriously and complies with all of your obligations, you want to know that all your competitors are doing the same. So you need a good enforcement body. You need the tribunals, you need enforcement bodies to do their job, because if they're toothless, your competitors don't care. And then it
Yeah.
becomes almost like a moral issue to follow the law. So yeah, I think the other is that, again, Labour are looking to strengthen this, create a new enforcement body that will bring together a whole bunch of other enforcement responsibilities. And we should then hopefully see, one, a reduction in volume of claims in the tribunals, freeing up time to hear more sort of meaty claims, but also these sort of low value claims should become something that employees can find a better way to enforce. And again, that should help good employers compete fairly.
Excellent. Well, thank you so much, David, for joining and giving us pretty pretty thorough update. I know we haven't included every detail, otherwise this would have been probably 2 or 3 hours long. I think if people need to go further, then probably more a case of contacting you directly, isn't it? And we can
Yeah,
we
yeah,
can include
absolutely.
your
I mean,
details
as I said,
below.
though, although at the moment a lot of it is quite speculative, so it's probably more to follow the news and follow commentators in the region. But yeah, getting in touch, we're always happy to hear from anybody who might want to review the way they work and see if there's any changes coming in that might be an issue for them. So
Thank you very much indeed, David, for joining us.
lovely. Thanks, James.
Thank you.